All right. Welcome to the City of Knoxville Board of Zoning Appeals. I'm Amy Sherrill. I'm the chair of the BZA, and I'll be conducting today's meeting. Alongside of me are the other members of the BZA, and at the tables across the table are the city staff members. Today's meeting will be conducted in the order of the agenda. Agendas are available at the table near the entrance. Pursuant to BZA's administrative rules, each matter on the agenda will be considered in the following order: staff comments, proponents, opponents, rebuttals, discussion among board members, motion and a second, discussion among board members, and a vote. This part's really important. Members of the public may address the board, and the following rules apply. Each person may speak for 5 minutes and shall not have more than one time to speak, except that the chair may allow 2 minutes to the applicant for a rebuttal. When there's more than one person who wants to speak to an issue, each side is limited to 3 speakers with 5 minutes each. The board may ask questions of any speaker and may allow more time or more speakers via vote. Speakers should limit their remarks to the facts of the case and should avoid repeating comments that have been previously presented to the board. All speakers should come to the podium and speak directly into the microphone. Speakers will need to state your name and address for the record. Appeals of the decision of BZA are made to the Knoxville City Council. A petition for such an appeal shall be filed with the Plans Review and Building Inspections Department not more than 15 days from the date of the BZA decision. We now call roll.
Amy Sherrill,
Here.
Brad Salisbury,
Here.
Daniel Odell,
Here.
Kimberly Black.
Here.
Thank you. All right, the first item on our agenda is the minutes from our February 17th meeting.
Move to approve.
I'll second.
We have a motion and a second. All those in favor?
Aye.
All right. Our agenda is, we're going to have one item, new business, go back to old business and come back. The first item on the agenda is new business BZA 260019. And as our applicant makes their way up, we're going to hear staff comments.
The applicant is appealing the zoning administrator's determinations that CareCut's proposed services at 5200 Clinton Highway qualify as a religious land use and are exempt from the zoning code requirements. Approval pursuant to federal law, the Religious Land Use and Institutionalized Persons Act, and state law, the Tennessee Religious Freedom Restoration Act. The zoning administrator will be available to discuss their interpretation, and the city's attorney, Christina McGraw-Stillery, will also be present to address both federal and state law relating to this appeal.
Thank you. Before you speak, will you push the button that has the person on it? Excellent. And now will you give us your name and address for the record?
My name is David Hamilton. I'm the appellant on this one. My address is 1810 Merchant Drive, Knoxville, Tennessee 37912. I'm an attorney at law, and therefore, when I'm addressing certain legal applications, understand that I may be in conflict with other counsel on the interpretation of law, but I'm willing to defend it. The problem that we have here is that precedent to the request for religious exemption, this matter is already on the docket for the Planning Commission and was approved by the Planning Commission on January 8th. There's an appeal period that comes from that, and we did properly. There were actually 4 different appeals by different landowners or people with interest, and that appeal has not yet been heard. That's important. The zoning administrator is limited on what he can do according to the Knox County and the City of Knoxville ordinance. Article 15.1A and Table 15-1 remove any authority of the zoning administrator to review any special use applications. He has no authority. Under the law, that's considered ultra vires. It's not an error. He could, where someone that has authority made a mistake or otherwise in general application of their responsibilities did something negligently or even in error, just by understanding. This is a matter where it's black and white. He had no authority to consider what was before him. Why? Because the requirements of the, I believe it's Article 16.2G, a modification of an existing special use application requires a new special use application. That would mean that Carecuts needed to withdraw their special use win of January the 8th and then apply for a new one underneath, even if they were seeking something like a religious exemption, because it's still a special use application. I think in this one, it's questionable whether or not there was actually anything more than a letter seeking a special use application from the zoning administrator that does not meet the requirements of the code. And I'm going to be talking a lot about the responsibilities of what persons should have done and the authority granted to them, not whether or not it was a nice thing to do or something proper. He was not in the position to even make that decision. When he made that decision of applying for religious exemption, there's a lot of question about that. Why? The property is owned by a commercial entity. It is a commercial lot owned privately by a commercial developer. It is not owned by Carecuts. There's no lease been provided to Carecut or by Carecuts concerning how they intend to use the property or what is the relationship between an applicant compared to the owner. The applicant is actually a non-religious, non-profit 501c3. Now, they may do a lot of good, but the difference matters because it limits the potential of governmental grants if they were a religious entity. So they're taking their cake and eating it too. They're claiming a religious function, and yet legally they're not. They are a non-religious, non-profit. All right?
Your time is running to the end here.
All right, how much, because I'm only looking
you've got
at 6 minutes.
So it's 5 minutes for each speaker, and you have got about 15 seconds left.
Respectfully, the rules matter. And this should be refused. Thank you.
Thank you. Are there others here to speak in favor of the application, which is the appeal? Okay. So then we open now to the opponents of the appeal.
Ben Mullins, 550 West Main Street. I'm usually not an opponent here, but I do represent the applicant and Carecuts as well in this. And I'll say, first off, there is a special use application, but this determination of whether or not a religious exemption applies and whether or not we even have to go through the special use application is the very reason why we petitioned the zoning administrator for that determination. That's separate from the special use application altogether. You could do it beforehand, you could do it in the middle, you can do it afterwards. But the point is, if this interpretation is upheld and we are entitled to religious exemption through either federal or the state law equivalent, then that special use application doesn't move forward. It's outside of that process. We don't have to, amend it or go within the process. And that process is actually for an interpretation, and then the appeal for an interpretation is set out in section 16.12 of the zoning ordinance. So that's kind of collateral to this and not really, it shouldn't be an issue. In the written submissions, Mr. Hamilton didn't have time to get into it, but he also takes umbrage with a lot of the commercial site designs and the issues that are part of the special use application. Again, that's not what this board is determining. What this board is determining today is whether the zoning administrator's decision to say we don't have to go through the process of special use further if this is upheld is correct or not. And I want to go into that. Mr. Hamilton made a point about this being a nonprofit organization, but it was not initially incorporated as a religious organization. And that is true. It wasn't initially incorporated as a religious organization. It should have been. It could have been. When you fill out a nonprofit, you can check the box for a nonprofit organization, and they did not do that. But that's not determinative on this issue, as he would have you believe. A couple of things. I did submit and passed out the bylaws that were adopted at the same time this was incorporated in 2016. And section 1.2 clearly says the purpose of this corporation shall be to operate exclusively for charitable purposes as missions ministry that provides haircut to the homeless. So it was contemplated even at its inception. I also pointed some printouts I printed out today from their website talking about their mission is to restore dignity to the homeless and less fortunate through the love of Jesus Christ. And also their schedule for their Bible studies and their Sunday worship services that they do at their current location and intend to do at the location on Clinton Highway. So do you have to be a church, or do you have to be a religiously organized nonprofit corporation to have these benefits? No, you don't. And the Supreme Court has actually told us you don't. There was a case in 2014, Burwell versus Hobby Lobby. Hobby Lobby is not a religious organization. They are a for-profit corporation, but they were entitled to certain exemptions from federal law under RLUIPA, one of the same statutes that Mr. Ahrens has cited to here in his determination. And of course, the court recognized that closely held for-profit corporations can be exempt from regulations that violate their owners' religious beliefs under the 1993 Religious Freedom Restorations Act as amended. So that's RLUIPA. Under the state statute, which is broader and provides more protections than the federal statute, it defines, he says, an individual, and that's not the case. It's no government shall substantially burden a person's free exercise of religion, and a person is broad enough to include a corporation, as those cases have stated before. But what does substantially burden mean? That is defined in the state statute specifically to say inhibit or curtail a religiously motivated practice. Here, that's exactly what is going on. This organization came together to provide services for the homeless because they had a religiously motivated intent and desire to do good in the community. I can go through all the services that they provide. It is in the application. It is in Mr. Ahrens' is in his determination. But if this were to be upheld, then again, we don't have to go through this special use. If this were denied, the special use is already proceeding forward. So we have two paths to proceed here, but we do want to make sure that we move forward with this exemption because, I think it is not proper to require a group like this to go through a special use application when those same services, if they were provided to people who were not homeless, would be permitted under the zoning ordinance. So that is certainly a substantial burden to their religiously motivated practice here. So I think Mr. Ahrens got it right. I think this should be upheld, and I'm happy to answer any questions.
Thank you. Are there others here to speak in favor, in opposition? Okay, very good. At this time, we'll open it to the board for discussion.
Got a question for Mr. Reel. Does the exemption follow the property? Does the exemption follow the use? As if there's a change of use in the future, does that, pardon me, Mr. Aaron's?
It's the use.
So-
We're not talking about a variance here.
Okay,
We're looking at the use and determining whether or not it meets the qualifications for the religious exemption.
okay.
Any other, is everyone clear on what the question is? And do you all have any other questions of staff or either party?
I think I'm clear.
I'm ready to make a motion before we can continue discussion after that, but
Yeah, that's fine.
I move that we
Hold on.
deny.
Hold on one
Go ahead.
I'm not familiar with your process. My reply to their response,
If you would like a rebuttal, you can have 2 minutes for a rebuttal.
I appreciate that.
Okay.
I think you're missing the point. It's not whether or not Care Cuts is doing a good thing. It's whether or not the zoning administrator had any authority to consider any of this, number one. Number two, and more important, the application for special use is a land zoning issue. It is not it goes and travels with the land. If you change a zoning or other use of the property and change it, then it travels with the land. What is not being responded to is whether or not the special use will now exempt the property from taxation or other issues. The implications are much larger than just the special use when you do this. And quite frankly, I think that the zoning administrator exceeded his authority because it was already before the planning commission on special use, and they're the ones who are supposed to take it, and that's going to be later this afternoon. I appreciate the opportunity to present this, but the question is whether or not the zoning administrator actually had the authority when it's removed by ordinance. Thank you.
Thank you. So I'm going to ask staff a question here. So we're simply, what are we being asked? What is in our purview to decide today?
So you're being asked today to either approve the appeal, which would mean you overturn the zoning administrator decision on this, or deny the appeal, which would allow his decision to stand.
Okay. And what the rebuttal was on the basis, right, of authority or lack of authority. And do we have any say over authority?
So the RLUIPA is actually an extension of civil rights protections, and it actually preempts our ordinance to that extent where it has a conflict. And in our zoning administrator's determination, this qualifies as a religious land use, and therefore, that triggers that federal protection. And so I'm not aware of any part of the federal law or the state Religious Restoration Act that specifically requires one particular person or one particular body to make that decision. I hear what Mr. Hamilton is saying, special uses go through planning commission. And yes, that is a separate process. It goes to city council this evening on a second level of an appeal, but we're not talking about a special use being granted here.
Okay, I just wanted to make sure we separate to only consider what we really have purview on.
I need a little bit more definition from you on what you mean by the separation of use is determined by zoning code and the other process that we're talking about going through commission.
So the Social Services Center, and correct me if I'm wrong here, is a in the CH1 zoning district where this property is located, it's only able to be installed with special use approval from the Planning Commission. Now, they gave that approval back on, I believe, January 8th of this year. Now, they do look at a variety of other standards in the zoning code in granting or denying that special use approval. Again, this is separate from that process because the way that the federal and state laws on this topic require us to look at it is not, is a social services center appropriate here? Does it meet the standards of special use? We're looking at it from a lens of, is this a religious land use? And are we required to make an exception here? And, as Mr. Mullins pointed out, if you had a non-religious group providing similar services there, are they treated differently in this context because of the religious component to it? Those are the things we have to consider.
I've never done anything with a religious land use attached to it before.
doesn't come
so I feel
often,
very
yeah.
uneducated on it. This is, educate me more on what the zoning code does say relative to religious land use, not just like, how do you think about that, Peter? Like, what is that? Or, sorry.
So
Well, it's
because
Peter's determination though, right?
it is, we work on
Okay.
it together whenever there's a federal
Okay.
legal question involved. But I will say, in terms of the zoning code, we don't have a RLUIPA section that parallels the state or federal sections of the law. We use the law that's out there because it preempts our ordinance anyway. So that protects us from having to keep updating it if there's a change to the federal or state law. But we don't have to keep bringing code changes back and forth.
Essentially, when the question was asked of me, I went to my attorney, who knows federal and state laws, to see if it met. And that's where I rely on her expertise to help make that determination.
It's just interesting to me that this element does exist though, under your authority as the zoning administrator relative to zoning. But we're really talking about laws that apply elsewhere, if I'm hearing you right, or preempt. You're using the word preempt. So there's other law that is actually weighing in on. That's a little different than what I'm used to relative to the rest of zoning. It's kind of defined by the code, right?
This is a question of whether or not we even open up the zoning code.
It's almost like it's the authority of whether the zoning is applicable. And that's the
Right.
determination was that it wasn't applicable due to the religious
Well,
exemption.
and I do want to clarify one thing. The RLUIPA exception that was granted here is not a rubber stamp, a complete pass on all the zoning requirements.
Yeah.
The request that was made was, being able to be a permitted use without special use approval. That is the only bit that has been approved so far. We still have to talk about other things like traffic safety, parking spaces, there are things that may require some variances here. But that is a very limited exception that we have given thus far. They're not far along in their plans for us to evaluate anything else at this point.
So in hearing that, it's when you went back to, are they being held to a different standard? A barber shop or a hair salon would be what would be the comparable non-religious version? So because there are these other services that come along with the religious mission, they fall under social services, which is what requires a special use. If they were, what would be the comparable thing that's like the comparison? Is it a barber shop and a salon, and that would be allowable? And that I'm just trying to understand what would be the non-religious peer?
Commercial use.
Any.
Yeah, the comparable commercial use.
Yeah.
You're asking about what it would be in the use matrix if it were not serving a certain demographic, it would be just open to the public where they'd provide haircuts?
If it was commercial hairstyles or styling or a salon.
Personal service establishment?
Which would be allowed.
Correct.
I think so.
Okay. I mean, I think that's just, I'm confirming, that's my understanding, is that if they just purely were a personal services establishment, it would be allowed. But because there's a religious component to it, it kicks them into a different category?
No, so it would be classified as a social service center, which provides assistance for those recovering from drug or alcohol dependency. And there's a bunch of other stuff, but that's what they're classified as. But because they're also a religious group doing that thing, that's why
It is part of their business.
yes.
Okay, got it.
The
Okay,
business model.
okay. Sorry, like Daniel, this is new territory for me to understand. Okay. Any other questions?
I'm still ready to make a motion. Let's see if I get this right. I move that we deny the appeal of the zoning administrator based on the fact that the proposed use falls within the definitions of religious exercise under their, our LUPA, and that the proposed tenant also appears to fall within that realm.
Okay.
So just to confirm, upholding the zoning code administrator's
Correct.
decision. Okay.
I'll second that for purpose of one, but I have a question there. Why are we,
Hold on. So we have a motion and a second, and we'll open for additional board discussion.
my quick question there is, we're talking about our loop, but I'm not an attorney. Like, can we
Page 9 of the, so our LUPA, from what I can see in what's been provided, it allows for religious exercise, which includes operations of homeless shelters, soup kitchens, other social services, accessory uses as fellowship halls, parish halls, similar buildings or rooms. Even where facilities would be used for both secular and religious educational activities. So it's pretty wide ranging.
Daniel, Brad is reading from the statement of the Department of Justice on the RLUPA, that handout being provided in there. Yeah.
More questions?
I'm willing to uphold that motion, but there's a lot of detail to that. Okay, let's just vote.
Okay. Any further discussion? Kim, Brad? Okay. So there is a motion to uphold the administrator's decision, which would be a denial of the appeal. All those in favor?
Aye.
Aye.
All those opposed? Okay, the appeal has been denied. The appeal has been denied. Thank you all for your time. Okay. The next item on our agenda is moving to old business, which is BZA 260005. Is our applicant with us? Okay. Are they our applicant? We're gonna take just a couple of minutes, let everyone settle back down.
Yes, I'm here for that case. I apologize.
I can't hear him. Can someone shut that back door once the group's out? Thank you. Oh. Okay. I think we're ready to proceed again. Okay, and I think our applicant is online, is that correct?
Yes,
Okay, very good. Before you begin, we're gonna have the staff give us their comments.
Yes, the applicant is requesting one variance related to a proposed detached pylon sign in the CG2 zoning district. The request is to decrease the minimum required setback for a detached sign in the CG2 zoning district from 15 feet from the edge of pavement to 12.2 feet from the edge of pavement. The The applicant proposes to alter the existing detached pylon sign by replacing the current sign head with updated signage. This alteration requires the new sign to comply with the currently adopted sign ordinance. The proposed sign meets the applicable area and height standards, however, it does not comply with the required setbacks. The applicant should address whether alternative locations on the property were evaluated that would meet the setback requirements.
Thank you. All right, if our applicant can begin with your name and address for the record, please.
Randy Ridge, 4332 Duval Street in Chattanooga.
Is the volume up as much as it can be? It's a little bit muffled to hear you, so we're checking to see if we can adjust on our end. All right, would you test one more time?
Sure, is that better?
Yeah, I think we can work with that. Thank you.
Yes. Did you get that address, or should I repeat that?
Duval Street, Chattanooga.
Duval Street, Chattanooga. Yes, ma'am.
Awesome, very good. All right, if you'll proceed with your request and your hardship.
Yes, ma'am. We're looking to replace this 1960s era sign. The maintenance and upkeep on a sign of this age is kind of similar to the maintenance and upkeep on a 1960s era vehicle. Parts become harder to find, and it's just a lot of the parts are frankly obsolete. I would like to point out that our proposed sign is approximately 16 feet shorter than the existing sign. The existing sign exists at roughly a height of 36 feet. Our proposed new sign would be 20 feet tall. I did want to clear up what might be a little bit foggy in the request. The 12.2 setback, that would actually be to the post. This current existing sign is a twin pole sign. Our proposed new sign would be a single pole sign. That pole would sit 12.2 feet off of the property line. The width of the new sign cabinet is roughly 10 feet. So then you would have a 5-foot projection into that 12.2 foot setback. So the outside edge of the sign, if that's how Knoxville measures their setbacks, that would be roughly 7.5 feet from the property line. But this sign is considerably shorter. It's much smaller than the current sign. So the view would actually open up there on North Broadway if we would be granted the variance and allowed to erect this new sign.
Thank you for that. Can you, well, let me first, is there anyone else here to speak in favor or opposition of this item? Okay, with that, we can open to board discussion. One thing I'd like to ask is for the applicant, can you explicitly tell us what you're stating your hardship is?
A hardship is just keeping the new sign functional, finding parts for the existing sign. Again, this new sign is only 2.2 feet out of the right of way. We would like to bring the sign back further from the right of way by about 5 feet and just create a safer situation. But the hardship is the current configuration of the building in relationship to the property line. As you can see, the building itself is relatively close to the right of way, and this is simply the only grassy area that we have where we could erect a freestanding sign. Once you get into a situation where you're moving a sign into a parking lot, then you start affecting drive aisles and traffic flows, and you can place bollards around the base of the sign, but it's common for those even to get hit if the sign is actually located in the parking lot.
Okay, thank you for clarifying your hardship.
Sure.
Open it up for board discussion.
So where do we typically measure? Is it from the foundation or is it from the edge of the sign?
No, the measurement comes from the edge of the sign head, and it sounds like there was some confusion because when I reached out to someone else with the same company that the representative is speaking about now, the measurement I was given was 12.2, and when I clarified on the site plan if that was to the edge of the sign head, I got an email response back to yes, that is correct, and so that is what the public notice showed. It sounds as though that it might be different than what was advertised, and if it's less than what was advertised, it will need to be at next month's meeting.
Okay, so before we go any further to the applicant, if you need something greater than what would a greater variance, which would be a lesser distance, then our recommendation would be that we make a postponement and then allow you the time to revise your application and have it re-advertised to appear at a later meeting.
Will this case automatically be rolled to the next meeting, or will this be a new application process all around?
If the application is postponed by the board, then it will automatically roll to the next meeting.
I understand.
We will just ask that the site plan reflect a measurement from the edge of the sign face and not the foundation.
So you'll just work directly with staff to revise the request so that it's accurate to what you're actually needing.
Sure.
So are you agreeable to us making a motion to postpone?
Yes.
Okay.
I make the motion that we postpone item BZA 26005 to the April meeting.
I'll say.
We have a motion and a second. All those in favor?
Aye.
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 All right, thank you. This item's been postponed.
Thank you.
All right, next item is BZA 260011, and our applicant is coming up. So can we have staff comments, please?
Yes, the applicant is requesting 3 variances related to proposed garage and ADU in an R2 zoning district. The first request is to increase the maximum allowed building coverage in an R2 zoning district from 30% to 32.5%. The second request is to increase the maximum allowed impervious surface coverage in an R2 zoning district from 40% to 46%. The third request is to decrease the minimum required rear setback for a detached garage with doors oriented towards an alley in an R2 zoning district from 12 feet to 5 feet. Based on KGIS, the lot has a width of 47 feet, which classifies it as a non-conforming lot of record, as the R2 zoning district requires a minimum lot width of 50 feet. However, even if the lot were conforming at 50 feet in width, variances for both building coverage and impervious surface coverage would still be required for the proposed project. The applicant has revised the request since the February meeting, reducing all requests except for the setback reduction. Engineering staff is available to discuss the safety and functionality of access to the detached garage in relation to the alley. The applicant should also explain how the request meets the hardship criteria outlined in Article 16.3.e.
Thank you. Will you state your name and address for the record?
Sarah Martin, 1121 Eleanor Street.
Thank you. And will you describe your request and hardship?
Yeah, so the hardship is the non-conforming lot of record in addition to the lot size that was mentioned by the staff comments. There's the side setback, which you can see is violated by the main house on the survey. So it's one of these cases, as we often see in these historic neighborhoods, where the current zoning does not match the historic development patterns. So we have those kinds of lines being violated in a few places on that site. The proposal is for this detached accessory structure in the back. And as was mentioned by staff, we've reduced the size of it since last time, as well as the amount of impervious surface to get that as little as we can for what the client's trying to achieve. And our main goal is to propose something that fits with the historic development pattern of the neighborhood and does not stick out. This particular neighbor has a house 4 or 5 houses down on the next block that in 2021, we had a very similar application for. I was just looking back at that one. And it had I think about a 32.9% building coverage variance and the same 5% 5-foot setback off the rear. So that's kind of the precedent they're looking to, but also a good example of the continuity with the neighborhood fabric.
Thank you. Is there anyone else here to speak in favor or opposition of this item? Okay, very good. We will open it to board discussion. I will start with, I want to say thanks for taking this back and taking another look at that to reduce the number and the size of these requests. That
You're welcome. Yeah,
definitely
it's
helpful.
every little bit helps. We want to stick with the, like I said, the neighborhood development pattern that's there. So getting that size right is happy to massage that a little bit.
And I think, Brad, last month you asked a question about whether there was a safety issue on the garage being, I guess, the relationship to the alley,
I did.
just to reiterate that.
Engineering looked at the the site plan and the local conditions and determined there wouldn't be a site distance issue.
There would not?
Correct.
Okay. And for the rear setback, what is the reason that we can't slide the structure further into the property?
One of the hardships on this one is, I didn't mention this in the application because it's not about the extent of the property, but the topography is a lot higher at the alley than it is at the street, and it's fairly flat right at the alley, I think because of a historic structure that was demolished, an old accessory building. So you've got kind of a pad, and then it dramatically slopes, including a couple of retaining walls to hold the grade back as you go down. So that would make it much better to site it close to the alley.
Good.
Yeah. Any other questions or comments?
I think this is much better than where they were, and
Yeah.
it's very common. This is normal stuff that we've approved in these neighborhoods before, based on the size of the lots that are over there and the desire for the ADU over the garage type of thought process and design, and especially if topography is an issue here, which sounds like it is, at least a thought process. I think where they placed it makes sense. It preserves the use of their lot laterally, long wise. So I make a motion to approve BZA 260011 as submitted based on the hardships that they've defined in their application and topography.
Very good. We have a motion. Do we have a second?
Second.
All right, we have a motion and a second. Any further discussion? Okay, all those in favor? Aye.
All right.
All those opposed? Very good. The variance is passed.
Thank you.
Thank you. All right. On to new business again. BZA 260013 is our applicant with us. As they're making their way up, can we have staff comments?
The applicant is requesting one variance related to a proposed single-family dwelling in an R2 zoning district. The request is to decrease the minimum off-street parking requirements for a single-family dwelling in an R2 zoning district from 2 to 0. The property is a non-conforming lot of record with respect to both lot width and lot area. Based on KGIS approximations, the lot has a width of approximately 25 feet and a total area of about 3,500 square feet. The property is currently developed with a single-family dwelling that does not have off-street parking or alley access. Due to its condition, the existing structure will be demolished. The applicant proposes to construct a new single-family dwelling within the existing building footprint. However, this configuration does not provide sufficient space in front of the dwelling to accommodate a compliant driveway for 2 vehicles, and the proposed setbacks are also non-compliant. This project will be reviewed by the Historic Zoning Commission later this week. If the proposal meets the applicable neighborhood design guidelines, the setbacks may be reduced through a certificate of appropriateness rather than a variance from the Board of Zoning Appeals. The applicant should address why the proposed dwelling cannot be sited farther from Canceller Avenue in order to provide adequate space for a compliant driveway accommodating 2 vehicles.
Thank you. Will you state your name and address for the record?
Yes, Allie Chamberlain, 1501 Granger Avenue.
Thank you. Very good. And then describe your request and hardship.
Yeah, so a little bit of backstory on this is there's an existing house on this property that's a lot closer to the property lines on both sides. And originally we were going to reconstruct it, but the structure is so bad that we have to tear it down and build another one. But we can't build it in the same space because of the setbacks. So for the Historic Zoning Commission, we have to maintain a uniform setback in the front in order to maintain the historic portion of the neighborhood and make sure everything looks uniform. So we can't push the house back, and we have a lot of space in the back, but we also don't have an alley in the back. So we can't have parking in the front or the back, and the lot is already 25 feet wide, currently making the house about 16.7 feet wide. So the other option would be to go on the side, but then we have about, an 8-foot wide house. So there's a lot of complications there.
Yeah, an 8-foot White House, yeah, definitely. Is there anyone else here to speak in favor or opposition of this item? Okay, we can open for board discussion.
I think she meets the standards of a small lot.
Yeah, I'd say so.
And it looks like if it was to get pushed back, there's a series of stairs next door that I don't even know how that would work.
A series of stairs. Did you say next door?
Yeah.
Oh.
Josh, is there any problems with on-street parking?
It doesn't appear so. There's plenty of other cars that traditionally park on that street.
Loud boom. Okay. Any other comments or questions from the board?
I don't know what that noise was.
So do I.
Yeah,
I'm
no.
scared. I make a motion that we approve BZA 26013 based on a hardship of narrow lot width.
I'll second that.
All right, we have a motion and a second. Any further discussion? All those in favor?
Aye.
Aye. The variance has been granted. Thank you. Pretty sure the space shuttle just took off or something.
Yeah, that's weird.
Sonic boom. All right, next item on our agenda is BZA 260014. Is our applicant present? Looks like you are. Very good. Can we have staff comments before he begins?
The applicant is requesting two variances related to a proposed hotel in a DKG zoning district. The first request is to decrease the minimum required corner clearance in the DKG zoning district between intersecting streets classified as a local and an arterial from 100 feet to 31 feet. The second request is to increase the maximum allowed distance between building entries on building facades that abut a public right-of-way in a DKG zoning district from 50 feet to 55 feet, 8 5/8 of an inch. The property has a lot depth of approximately 86 feet along State Street. The proposed improvements include a circular one-way drive aisle along State Street to allow guests to load and unload. Engineering staff will be available to discuss the safety and functionality of the proposed driveway design. The second request relates to a DKG design standard that was not included in the Design Review Board Certificate of Appropriateness issued in January of this year. The applicant states that the standard cannot be met due to grade changes along West Summit Hill Drive, but notes that the project will include multiple entrances and exits along the remaining street frontages.
Thank you. Please state your name and address.
Adam Contop, 1025. With the engineering firm working on the project, I'm going to speak to the first variance, and our architect, Hitesh Patel, is also online. He'll speak to the second one. This project has build-to zones on 3 streets, but due to the abnormality of 3 streets, we got a design review board allowed us to be a little set back off State Street. We were wanting to have a drop-off area for the guests at the hotel. And so we need to have 2 driveways to do that. State Street is the less travel of the streets. It's only an entrance-only driveway, so this will remove queuing off of State Street. And there's also utility conflicts, AT&T box, transformers, and et cetera. And engineering's reviewed it and does not have a safety concern per.
Okay, Thank you. That's all. Okay. All right. And then you said you've got other people here also to speak. Hitesh, did I see? Yeah.
Hello, good afternoon. This is Hitesh Patel at the Elevate Architecture Studio, and I can speak to the zoning request regarding the entrances along West Summit Hill Drive. When we looked at the site in overall context, there's a 8-foot grade differential from the corner of State Street to South Central Street. And in development of the hotel for the ground floor lobby, it became increasingly challenging to add multiple frontages along South Central Street due to the topography of the site, along with some dedicated or some existing easements, which would then consistently kind of constrict the site on what was usable along Summit Hill Drive. Our thought was to reposition the entrance towards the center of the Moxie lobby, therefore having access off Summit Hill Drive directly right into the center of the lobby there. We're asking for a variance by a few feet just due to the topographical challenges of adding additional steps and stairs was becoming increasingly prohibitive to meet that requirement. Additionally, our lobby is only about 3,300 square feet. So, and we are providing currently three entrances, one off of State Street, one off of Summit Hill, and one off South Central to address the pedestrian access on all three street frontages.
Thank you. Are there any others here to speak in favor or opposition of this item? Okay, very good. We'll open it for board discussion.
This is an interesting site plan.
All right, just to reiterate what I think I heard, you're saying the reason we have two entrances off of State Street as opposed to one off of Summit Hill was grade?
Do you mean the pedestrian entrance or the vehicle entrance?
No, your vehicle, sorry, I'm looking at Adam, sorry. Yes, you.
Okay.
Sorry.
We have a build to zone and build to percentage on Summit Hill, and so we could not place one there. The grade is also difficult, and if you did place one on Summit Hill Drive and somehow dealt with the grade, you'd actually be closer to the intersection. It'd be more of a safety issue because Summit Hill gets, I don't know the data, but multiple times the trips of State Street. And we're doing a one-way driveway to, there's not enough room on the site to maneuver in, so cars have to follow a one-way path.
Okay, thanks. I just want to make sure I understood the hardship there.
I think, could I also add to that? When we were working through the development of the plan as well, we knew how busy Summit Hill and South Central were in terms of just traffic. So our goal was to always, try to mitigate that and don't have any vehicular kind of standing room only off of West Summit Hill Drive, but be able to bring cars onto the site because this is going to be 100% valet. So this opportunity of the drive aisle will also allow, cars to stack appropriately based on valet sequencing to avoid any kind of car stacking issues along Summit Hill or State Street as well.
Okay, thank you.
Josh, what do you got?
Just to say that after the development team realized all the site constraints that Adam pointed out, they did coordinate with city engineering to come up with this site design.
Yeah, I think it's really thoughtful design, actually. It's pulling your traffic all the way away from, as much as you can, from a difficult intersection downtown.
And it is 100% valet?
It is.
No, and I think likewise, looking at the building entrances, getting within less than 6 feet of that, I think is,
We did provide an exhibit as well as on the building elevation page as well. That may help to clarify what the building elevation looks like on that.
it does. Thank you very much for doing that. Any other questions or comments from the board?
I'll make a motion to approve BZA 260014 on the basis of existing site topography and how they're going to deal with that, and on the hardships that they have defined here in their application.
I'll second.
Before we take that to a vote, do we need to more explicitly repeat those hardships, or is noting them in the application enough?
I think I heard that, but I also heard topography, the siting issues. Okay, I think that's fine.
Okay, just making sure we're compliant.
So I do have a question. So it's gone to DRB and been approved. Is this substantially different than what was approved at Downtown Design Review Board? Okay.
No, just to clarify, Design Review Board, they can give exceptions to table 5.3 for dimensional standards. However, they can't give exceptions for article or table 5.5-4 design standards. And so because this comes out of the design standards table, therefore they would need a variance if they did not meet that.
Yep.
Okay. Do we have a motion? Oh, sorry, yes, we do. Never mind. We have a motion and a second. All those in favor?
Aye.
Aye. All right, the motion has been granted or approved. Working on more coffee.
Most of my motion not good enough for you.
It was, we just, no, please no. Okay, next item here is BZA 260015. Is our applicant with us? Looks like she is, so have staff comments. Oh, and there's online as well. Great.
The applicant is requesting 5 variances related to incidental signs for a proposed gas station in an IG/IH zoning district. First request is to increase the maximum area of an incidental sign on a large site identified as sign D3 from 16 square feet to 32 square feet. Second request is to increase the maximum sign area of an incidental sign on a large site identified as sign D4 from 16 square feet to 32 square feet. Third request is to increase the maximum area of an incidental sign on a large site identified as sign D5 from 16 square feet to 32 square feet. The fourth request is to decrease the minimum setback for an incidental sign on a large site identified as sign D1 from 10 feet from a street right-of-way to 6 feet 10 inches. The fifth request is to decrease the minimum setback for an incidental sign on a large site identified as sign D2 from 10 feet from a street right-of-way to 6 feet 10 inches. The property is over 2.5 acres in size and therefore qualifies as a large site eligible for incidental signs, subject to the standards in Article 13.6.d. The applicant states that because the gas station will also serve semi-trucks, larger directional signs are necessary to help direct truck traffic away from passenger vehicle entrances and exits. The applicant also indicates the directional signs for passenger vehicles cannot be moved further into the site without creating conflicts with the drive aisles.
Thank you. So our applicant is online, is that correct?
Yes.
Okay, very good. Will you state your name and address for the record, please?
Colin Woodcook, 112 Woodlawn Drive, Chattanooga, Tennessee.
Okay, very good. And then will you describe your request and hardships?
Okay, so with this particular location and its large footprint, and we have mixed use of commercial and private vehicles, it's imperative that we kind of on the same footprint keep them separate for safety reasons, which is why we're actually asking for D1, or I'm sorry, D3, 4, and 5. The placement, it provides clear and visible guidance to all motorists entering and exiting the site, thereby reducing potential conflicts between the vehicle types, being it the 18-wheelers versus a private use vehicle. And D1 and D2, which we're asking to go from a 10-foot setback to a 6-foot 10 setback, improves the actual drive path and will eliminate some of the commercial vehicles trying to come into the autos only entrance. by just moving it back by about 3'8".
Okay. Are there any others here to speak in favor or opposition of this item? Okay, we've got someone here to speak in opposition. State your name and address, please.
Thank you. Kevin Murphy, 4508 Murphy Road. I'm here on behalf of the Board of Scenic Knoxville to oppose these variances. First, I'll address variances 1 through 3, which are the request for the larger directional signs, the increase of 16 square feet to 32 square feet. The applicant stated in the application that this larger is consistent with their established 7-Eleven's established design package. We at Scenic Knoxville would submit that 7-Eleven doesn't define the sign sizes and such for the city of Knoxville. That's the city of Knoxville's city council that decides that. And granting would be an arbitrary increase from 16 to 32 square feet in this case would essentially allow any applicant to also request that same size increase. So on variances 1 through 3, request you deny that. Simply there is not a hardship that requires making these signs larger. 4x4 sign can be seen, 4 foot by 4 foot, which is 16 square foot. That can be seen by a driver, even of a large commercial vehicle, and listen to. Secondly, on variances 4 and 5, which is a reduction in this required setback, the applicant has a clean site. They have demolished and are completely regrading and redoing the entire site there. So they started with a clean slate for the site design. They've chosen to place their drive aisles at a position that is 6 feet 10 inches away from the property line, while they had full knowledge of all the of all the design requirements, including the sign setbacks required. So they have created their own, by putting their asphalt in their drive aisle only 6 feet 10 inches away and not leaving a place for a sign. They have created their own hardship in this case. And if you create your own hardship, you're not entitled to relief from that. So we respectfully request you deny it on that basis. Thank you.
Thank you. Are there any other speakers present? Okay, we will now open up for board discussion.
I've yet to hear hardship. So I believe this one is solely self-created.
Applicant, you do have an opportunity for rebuttal, and if you'd like to address the question of giving us an explicit hardship.
Sure. Obviously, like I said, with the footprint this large and having the 18-wheelers, the 4x4 signs going from 4x4 to 8x8, going from 16 square feet to 32 square feet. When you're up at driving in an 18-wheeler, obviously the larger sign is better for safety of the public, which it is a mixed-use property. So you're going to be mixing the public with commercial vehicles. I understand that 7-Eleven doesn't set the precedent for this, obviously, but it is in good faith trying to help the public safety on this actual site, as well as D1 and D2 at the private auto entrance. We're not trying to set a precedence for it. We are simply just trying to make it more of a safe environment for the public.
Okay, thank you. I guess for you can go first.
I'm just going to say we've got a lot of directional signs in and around the city that are much less than 32 square feet in size that are seen by heavy equipment, tractor trailers, and regular vehicles traffic on a consistent basis, doing 55 miles an hour, not turning into a site at 15. So
That was my question. Actually, was for engineering, and that these larger signs closer to the property line. Are there any concerns about visibility? Not of the sign, but of traffic.
That's not something we typically look at in our department, but I would kind of echo Brad to say we have.
So, I mean, but whether or not a car coming in or out can see other cars, you do look at that.
Is the site triangle?
Site distance, yeah. We didn't have an issue with the site distance in this case.
I'm ready to make a motion.
Yeah, I don't mind that. I will say I'm struggling here too on this being a created condition and there are no obvious characteristics of the lot that stand out as hardships to me.
I make the motion that we deny the request of BZA 26015, number 1, number 2, number 3, number 4, and number 5 for lack of hardship.
I will second that.
We have a motion and a second. Any further discussion? All those in favor?
Aye.
Aye.
Okay. Next item on the agenda is BZA 260016. It looks like our applicant is coming forward. Staff comments?
The applicant is requesting one variance related to a proposed single-family dwelling in an R2 zoning district. The request is to decrease the minimum required rear setback in an R2 zoning district from 25 feet to 11.4 feet. The property was developed with a single-family dwelling and received a permit for an addition, to enlarge the structure's footprint in November 2025. However, during an inspection of the project, a building inspector determined that the work exceeded the approved scope as the original structure had been mostly raised. As a result, the applicant was required to apply for a new construction permit. The proposed structure maintains the original setback from the rear property line at 11.4 feet. Engineering staff is available to discuss the applicable standards regarding the creek located at the rear of the property.
Thank you. Will you state your name and address for the record?
I'm Linda Howard, 5317 Salem Church Road, Knoxville, Tennessee.
Thank you. And will you describe your request and hardship?
I'm requesting the variance for the back lot line. The original structure, as he explained, was permitted for an addition. We built the structure, and then during the inspection phase, this was reclassified as a new build. And the hardship is the building's already up, and it's in the original place for the original structure has been there for 80 years, and it has not moved.
Thank you.
I took this dilapidated building and revamped it, rebuilt it, and it is no longer, it's a single-family dwelling home, and as you can see on the plat, it's of the rear of the building is where the variance is 11 feet, 4 inches.
In the staff comments, there is a reference to floodplain.
I do have a certificate of elevation for this building. It does meet the requirements of not being in the flood. The height, the elevation.
So how does that affect the property?
I don't know how it would affect this request, but the type of floodplain it is just would require her to elevate the house. I don't think we've approved the EC, but the fact that she has one shows that she knows that she has to have one.
Okay. I just didn't know if it was relevant to the setback since it was mentioned in the staff report.
Right.
Okay.
So it was considered a rebuild during inspections?
There was a permit issued for an addition, and during the course of inspections, the inspector said there's not enough of this that remains. I'm assuming, were you present?
Well, the part that was the addition that we were gonna add on to, when we got into the construction of it, was so far dilapidated that the wood was rotten. We replaced those walls with new wood. And that's where the inspector reclassified it as new construction.
When was it last occupied as a residence?
I don't know that exact number, but it's been only 4 or 5 years.
Essentially, the addition was permitted with the understanding that the existing house was still structurally sound. When they removed the wall coverings, they realized it's not. And so that's why it had to be replaced.
Yeah.
So did the addition encroach into the rear setback?
It doesn't, it looks like the addition is actually on the front.
Correct.
So-
From what I could tell on the site plan, Ms. Howard might be able to explain that a little bit better than I could, but.
So in this particular case, the rear is down, correct?
Correct.
It's like this lot was divided 3 times.
Yeah.
I have handouts that would help us clarify this.
You're welcome to share that. You can see in the aerial the sort of the footprint of the original home, and it was set pretty far back in the lot.
That's okay, I'll take care of it.
Thank you.
Awesome, thank you. Thank you. Mark, at what point does this fall under existing non-conforming versus?
Well, since it was an addition that was voluntarily raised, since it was a structure that was voluntarily raised, it no longer has that status.
Okay.
In the plat, you can see where the original outline of the house was. The addition was to the front of the house. I did extend the left side of the house 3 feet and extended the front 14.
Yeah, the site plan that's on the screen, which is slide number 8 on the tablet, I believe it's the blue box that's towards the front and then goes a little bit to the left. I believe that's the outline of what is new, completely new. And then the original structure obviously is that 1-story frame that's there.
Out of curiosity, what would the front setback be on this?
I don't have that in front of me, but it's 25 feet, and the front is the very top line. That's shown on the screen.
When I see where they're saying the front, I'm just curious, like, in this case, I understand you're working on a house and things happen and they're trying to stay in the same footprint. I don't even know how far forward could they have moved it and not have been here for another variance, I guess is where I'm headed with that question.
Well,
Yeah,
and if you're from a construction process, did you tear, maybe you said this already, forgive me if you did, but did you tear the whole thing down and rebuild, or did you?
No, we started with the addition on that, and as we began to connect the new building onto the old build, it just kept falling apart. So we
Right,
took
you
that down and we
pulled it
built.
apart, you started
Right.
having to replace structure as you went through the structure.
Right.
So you didn't pull it all down and then just put it back?
No,
on
it
the
wasn't
same foundation?
intentional. It was never supposed to be a new build. Otherwise, I would have elevated the entire house. We were trying to keep the integrity of the original house and keep that in place. But it being the age it was, the wood was just not, it would cause more problems down the road than to go ahead and replace
Sure.
what we did.
Which inspection, I'm just curious, were you at? What were you getting inspected when you called out today?
I was out of town at the time, but I think it was framing and electrical is whenever this was incurred.
In my mind, that in and of itself, from a process standpoint, makes it a little different than if it was somebody that just tore it down and put it back up.
No, I think, I've encountered this in multifamily and commercial, unfortunately. Sometimes you have high hopes for things being in better shape than they are, and I think at least.
It's always the case.
It's always the case, right?
The fact that it's not further encouraging than the original and, understanding the intent here.
So from that standpoint, it's a reclassification by default in some ways. I would say it's almost, if she came and asked for this prior to, I would have said yes because it's existing footprint. Almost like, I guess, is it too
Not
far to say
making it.
pre-existing non-conforming? Maybe that's too far, but
I guess that's my question. So was this lot platted and it was non-conforming just as it was platted because of the rear setback?
I'm just saying the house was non-conforming. The foundation itself was.
I'm not sure that the lot is not non-conforming too.
Yeah.
That's why I was asking. It's like by the time you said.
Well, if that house was moved forward, the lot would.
I'm not sure they wouldn't be here for a different variance was my.
I gotcha.
I think they would have had to have a variance when they platted it because there's no way it's bigger than 5 acres.
So as I'm looking at the city ward map, it doesn't appear that it's ever been platted. So we would defer to engineering, who's has in the stormwater ordinance some standards for single family and 2-family dwellings when they go for construction and permits.
I haven't done that record research at this point, but if it's been in this configuration long enough, then we have the ability to waive the plat requirement.
Can I make a motion?
Yeah.
I move that we approve BZA 26016 on the basis of a irregular lot shape and previous use.
And previous use?
And what issues?
Previous
Previous issues.
Previous use.
Previous use, I'm sorry. I'll second that motion.
All right, we have a motion and a second. Any further discussion? All those in favor?
Aye.
All those opposed? Variance has been granted.
Thank you.
All right, next on the agenda, BZA 260017 is our applicant with us. Very good. As he makes his way forward, may we have staff comments?
The applicant is requesting one variance related to a proposed gas station in a CH2 zoning district. The request is to decrease the minimum required interior side setback in a CH2 zoning district from 10 feet to 5 feet. The applicant was previously in discussions to lease the adjacent TDOT property to the north. According to documentation provided by the applicant, the parcel was ultimately purchased from TDOT by another individual during these negotiations. The applicant now wishes to proceed with the original site layout design, which requires a variance for the interior side setback from the northern building facade. The applicant should explain why revisions to the proposed layout cannot be made to meet the required interior side setback and bring the proposed building into compliance.
Thank you. If you'd state your name and address for the record.
Mark Horton, 4705 South 129th East Avenue, Tulsa, Oklahoma.
Thank you. And if you'll describe your request and hardship.
Sure. You pretty much stole my thunder on that one. You covered it pretty well. We're in middle permitting on this site. As you can see, it's a very long, narrow site. It's about the most narrow site that we can build this type of application here. We have, what you're looking at here is the current conditions. If you can flip to a one where it has the red highlighted areas. Keep going back to the first one. I think that's probably the best one to look at. Maybe one more. Or two more. There we go. These areas right here that you see is labeled as T-Dot lease parcels were originally part of a leasehold agreement that Quick Trip was going to acquire. We conformed at this point. We were considered a corner, and the corner setback was 20 feet. So this site complies here. Whenever the parcels were purchased, the situation changed. And so now if you go to the green highlighted slide. Yes, so those are deeded parcels now that are not right away. Those make us an interior lot, so we are beholden to the interior lot line setback, which is 10 feet. We have made some concessions to try to make this work. We've reduced one diesel bay. We have reduced one of the drive aisles to 30 feet, which is really our minimum in a situation like this. This is a travel center, and it services larger vehicles, not just larger passenger vehicles, but passenger vehicles that are pulling trailers. So we really need that double row parks on the south side of the building. Likewise, we also need a lot of area in the back for the diesel bay, for the diesel trucks to maneuver. So we're trying to balance all these things out. One of the other things we did was we moved the building south 5 feet. There were utility rooms access on the north side. We've revised the building design. We've moved all the access to the rear of the building. We've deepened the footings so that we can make the grades work. Not only is the site very narrow and long, it also has a lot of topography north to the south. There are retaining walls on both the north and the south side of the properties. In some places, they're up to 15 feet tall. So we're trying to balance all that stuff out. But with this 5-foot variance on the 10-foot setback, we believe we can make that work.
Thank you.
And I'm here for any questions.
So these are separate parcels, the parcel that has the building and the parking on it, and the area that's in green.
Yes, those are separate parcels.
But that you own both of them?
We
Or all of
own
them?
neither of those. They've been acquired by the leaseholder.
Okay.
He purchased them outright
Okay,
instead of leasing it to us.
so you don't have control
We
of the
do not have
property and the
control of
property
it.
lines. Are they part of your? I'm not even sure how to word that. So you're leasing the land and you're only leasing the one parcel? Or
So
are you leasing the whole
We own
set?
the lot, the larger lot, and the shaded parcels. They were originally a lease hold, and they were going to be assigned to us to use for this project. That did not come to fruition, and those parcels were purchased outright, and Quick Trip has not been able to secure those. So therefore,
Therefore, you're an interior.
they're separate. So they're, as you can see, they're not very developable. There's really nothing that we could determine that conforms to a use for those, other than something that Quick Trip would find benefit to, but we've not been able to secure those. So that's why we're asking for this request, so we can keep proceeding on through permitting. I think from the viewpoint of the public, they would know no difference. The building would actually be set 5 feet further away from the road, but the underlying conditions, there would not be any negative view from the public.
Had it have been adjacent to right-of-way, was there a setback? Sorry,
If it was a corner side,
yeah,
yes, it would have had a 20-foot setback.
okay, so it would have been bigger, okay. Okay. Anyone else have questions?
Josh, can you remind me again what the dimensional standards for parking stalls and drive aisles are in the city?
I can. Maybe more expedient, I would say that 26 plus 4, 30 feet is the maximum drive aisle width. For parking spaces adjacent to a curb, the maximum is 19.5 feet, which would affect those spaces directly planned south of the building.
What are the minimums?
The minimum for a parking space next to a curb is 15.5. Minimum two-way drive aisle for 90-degree is 26 feet. And the minimum for spaces adjacent to other spaces is 17.5 feet.
Thank you. I'm at a loss why we can't make minor adjustments to drive aisle widths and parking stalls and do away with this variance.
That's a good question. We've developed over 1,200 stores, and we have come to the insight that these dimensions work well for our use. The nature of our business is people getting in and out quickly. There are times in the day when we have more customers, like a morning rush, evening times. And so that we don't have 100 parking stalls, we have to make sure that they can get on and off the lot quickly. So with that said, we make sure that the parking stalls are large enough so they can park there. There's ample room for turning movements so they can pull in on the initial time. They don't need to do like a 3-point turn. And in this case, since this is a travel center adjacent to a interstate, we're going to have customers who are coming off that have even larger vehicles. People pulling trailers, we need that space there in the middle that you see the double row of parks for those types of vehicles to basically access those.
Yeah, I'm with you on this. I mean, I'm doing some simple math and finding 5 feet. That I understand that there's something that would be more desirable, but within the standards and requirements of the city, which is based on safety, it just seems like you could make this work.
And I understand the reasoning and I appreciate it. It does appear that this is somewhat of a self-created hardship, and that's where we're stuck in that we've got to take a look and there's a pretty strict definition as to what we are allowed and not allowed to approve.
Sure. Well, I understand your position. We've just have experience at it over many years, and we know what works best in the situation, and we're hoping that you grant us this variance so that we can continue operating in a manner that the public appreciates.
Any other comments or questions?
So the building, so the situation on the north side of the building is we will actually be further away from the road. The 20-foot setback is based off of that. It's two different lines. So we're looking at least 20 feet back from the northernmost line, which was the difference between the lease and the right and the T-Dot right-of-way versus 5 feet off of that bottom line. And so you're really getting a larger setback in essence. So the setback is there. It's even increased than what was originally.
Yeah, and I can certainly understand, what you're getting at with that. Unfortunately, that's not the property line. And so that puts you in a position, and us too, that we can't, you're hopping properties there to get to the right of way. So while I would agree it doesn't injure anyone necessarily in this case, there's still not a hardship that pushes it, I think, across for the requirement in my mind.
What happens if you don't get the variance here?
If we don't get the variance?
Yeah.
We'll take it back to management and tell them what the options are. We hold pretty fast to those dimensions I was telling you about, the aisles, the parking depths of the parking spots, the widths of those. In our check down box of what we would give up first, we would probably have to give up that middle aisle. So we would not have a place for those vehicles that get on our site to park, and they would probably just park randomly and potentially create like a safety issue. We've got large vehicles on the back. We've got semi trucks. People maybe parking back there. People moving trailers, moving trucks, families. They would probably have to find some place back there, which is not ideal.
How did you miss the leases on the front parcels? Like what happened there?
How do we miss them? That's a good question.
You had an agreement apparently, and then all of a sudden you didn't.
Right.
The thing I'm wrestling with a little bit is it's being truly self.
So, DOT sold those parcels to the developer after we had bought the properties.
I thought you were going to lease them from DOT. Were you?
It was an agreement with the developer that they were going to reassign those leases to us.
Okay. And then they just changed their mind? They just changed their mind about doing that?
They bought the properties, and they did so after we had purchased our property. So those were supposed to be assigned to us, and we've never been able to come to terms with them selling those parcels to us.
Okay.
Any further comments, questions? Is there a motion?
I'll go ahead and make the motion that we deny variance BZA 26017 for lack of hardship.
I'll second that motion.
All right, we have a motion and a second. Any further discussion? All right, all those in favor? Aye.
Aye.
All those opposed? Thank you. All right, the last item here is BZA 260018. Is our applicant with us? Very good. Can we have staff comments?
The applicant is requesting two variances related to an existing but never permitted detached accessory structure in an R1 zoning district. The first request is to decrease the minimum required interior side setback for detached accessory structure from 5 feet to 0.16 feet. The second request is to increase the maximum allowed height for a detached structure in an R1 zoning district from 18 feet to 21 feet 4 inches. According to KGIS aerial imagery, the structure was constructed sometime between 2022 and 2024 by the current property owner. Based on an elevation provided by the applicant, the primary dwelling has a height of 30 feet. The accessory structure has a mono-pitched roof, meaning the height of the structure must be measured from the highest point of the roof. The structure is non-habitable and is used for storage.
Thank you. You'll state your name and address for the record.
Anthony Carter, 505 Woodlawn Pike, Knoxville, Tennessee, 37920.
Thank you. And will you state your hardship or your request in hardship?
Sure. I am hardship. Going into this, I'll go ahead and probably say that it is self-created. The building is too tall. The building is there. It's unmovable. Going in, I've sat with your staff probably about 3 weeks ago. They've given me a couple of suggestions. It's in our application as well. As far as the decrease to the side of the property, that based off their suggestions, we've 1 hour interior sheetrock coating, 5/8 double coated, different layers, the way you install it. Exterior hardy siding, there's already hardy on it. Hardship is really, the house is built in 1928. There's no storage in the house. The basement is unusable. You can imagine what the closets look like in 1928. They're still like that. We had to think outside the box to start putting stuff for a family of 6. The lot size going down is very skinny. The back of the property, I'm sure zoning can tell you a little bit about it, more than even my, but I can't really build back there. Ground level, if you stand boots on the ground on my front road on Woodlawn Pike, line of sight 2 foot high on my porch, you cast back on to the detached building, the line of sight comes into right here, of almost about 8.5 foot high. I had to build to it to make it even usable because of grade going down to the property. It just drops that low. To make it even usable, I'm asking for a request to make that, I guess, to keep the building the way it is. We do have a couple of options. The backup plan, it's in, if you want to scroll to 6 of 10 in my application, it'll kind of tell you a line of sight just to give you a visual of what I was talking about. I did mention the fire rating. I've got that covered. And we're asking if this can all be contingent upon, well, we'll continue. I guess I'm open for questions.
So the roof eave of this building that's out of compliance is below the roof eave of the primary home?
Yes, sir. You
Probably
see,
looks
like
like a
yeah.
pretty substantial amount.
Yes, sir. When I originally built it, I thought that the height restrictions, like the way you built it, it was top of the height. I have learned since then, that I apologize. I guess sorry I ain't cutting it, but I'm learning from my mistakes of just the way that heights are built from a scallion, the lean-to style versus a gable.
So it was built without any permitting at all?
Yes, sir. You're looking at the person that did it. Yes, sir.
Is it plumbed and does it have electric?
No, sir. Does not have plumbing. And as far as codes, like I've passed you guys over there. I've sat with these guys also one time, about 3 weeks back. And these are my suggestions, based off of talking to these guys. This house we started, it's all because of an addition that we're trying to do to the side of the house. That the addition has been approved. We've been in the application process since August of last year. And it's held up now because of this. And this is where we stand.
Curious on the side lot line, your neighbor.
I built it according to a fence that was there. I really didn't. And it was there before I got there.
Yeah, it's hard to tell on here, but it
As
seems
bamboo,
like,
you can thank our neighbor 20 years back with 8 species of it.
seems like the neighbor most affected by that, their house happens to be pushed the other direction.
We do have, I know that this doesn't matter to you, but we have had a petition, not a petition, but we have had it doesn't bother our neighbors of us having this property there, any of us for surrounding.
So explain to me real quick again, excuse me, how the usability is affected by your hill slope. Like, I don't understand. your doors are designed down at the bottom of that hill slope?
Yes, sir.
Okay. But I think, did I mishear you? I thought you said that you built it this big for a usable reason?
Family of 6, there's no storage, not all, any
But
in the
nothing
house.
related to the slope of the hill itself from,
I'm sorry?
I think I misheard what you were saying earlier, but I thought I interpreted that, there was something about access to the structure from a higher elevation, which encouraged you to build it this way, but that's not what I see. And I think you're saying that's not true.
That's correct. I'm just trying to make it, from the road, aesthetically, I'm just trying to add to South Knoxville. And we are really trying. If you saw what the house looks like currently right now, you would understand really what we are trying to do to the house.
I've got to think through this one because I feel a little stuck right here.
Yes, sir.
I think, we've seen this before where you have an accessory, a garage or whatever that's built further in the property, and as the grade goes down, so I appreciate looking at them side by side because there's a depth there that the street perception is somewhere up
Right.
high in this case, that from the street, this structure does not appear to
Yeah, I
be
think-
21 feet tall, so like it's
Yeah.
out of compliance and it's not how it's applied. In this case, as far, I think there's some,
Yeah.
I can understand how that's hard to understand if you
Well,
haven't done it before.
Yeah, the height is giving me less pause than the side setback, because had he gotten permitted and come to us with this request, we probably would have said, no, you don't need to do this. There isn't a hardship.
Topography itself is not creating a hardship
No.
that would justify that design.
Because it
but
could have scooted.
this is one for me that I just don't see any practical, repercussion of this that
What good of it?
hurts anybody or matters, because from a visualization in the neighborhood, it looks fine. And it's a nicely built structure and
Yeah, I certainly wish I could hear from the neighbor themselves as opposed to me making assumptions, but looking, if their house were right,
seems like there's plenty of space
Yeah.
there, right?
that, again, it's impeding on the property line, it is what it is, but it would be nice to hear from them, but.
And if it's denied, they've got the ability to go to city council and request this variance from council.
Is there? Yeah.
I'll make a motion to approve.
I second.
Well, I
Or
need
you
to,
got
I need to state
finishers,
I need
yeah.
to state a reason for it before we second anything, because, it's, pre-existing to what? I mean, it is an existing structure.
But it's not like an 1890s.
It's not, but it's existing, and, what do you do with it? Is the hard decision point, and I think topography is a part of the equation, although maybe not the full, if it was originally asked, I'm not sure, but make a motion to approve based on topography and that it is an existing structure that is now in place and hard to do much with, period.
I'll second it so that we can move it forward. All right, so we have a motion and a second. Do we have further discussion? So all those in favor?
Aye.
Aye.
All those opposed? Aye.
Aye.
Okay, so we're split, so we need to flip the motion. So I'll make a motion here to deny the request based on a lack of hardship or per our matrix.
And I'll second.
Okay, so we have a motion and a second to deny it based on lack of hardship per our standards. All those in favor, aye.
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 All those opposed? Okay, so your options here are to appeal our decision,
Okay.
or to accept it and to make modifications.
So based off of what that is, thank you for allowing us to continue because it really in game, we just need to build our house.
Yeah.
So modifications to the building, we can drop the gable based off of what you see. and-
That'll really be up to discussion with the staff to review how to get it in conformance.
Okay.
Yeah, sorry, we can't.
Oh, so,
We can't help with that part.
so I'm just asking what I do from
good.
here, I guess. I apologize.
Yeah, so your options are to work with staff to determine what appropriate modification would get you into
Okay.
compliance, or to appeal our decision. They can help with both of those things.
We're not appealing anything and we're going this direction.
Okay. Well, we appreciate you. To end of our meeting here, other business, the next BZA meeting will be held on April 21st at 4 PM here in the main assembly. Yeah, okay, main assembly room, so next door. And with that, the meeting's adjourned.